All right, we are right at the top of the hour, so let's get this party started. All right. So, of course, the most important thing to do first is to welcome you all. Elaine, would you like to kick us off?
I would. Thank you, Robin. Good morning or good afternoon, depending on where you are. I'm Elaine Borkove. I'm the president of the Justice Management Institute. For those of you that don't know who JMI is, we are a nonprofit organization based in Virginia, although we have people who work all over the country. We are one of the 4 or 5 site coordinator organizations for the MacArthur Foundation Safety and Justice Challenge. And we provide direct technical assistance to 7 sites and technical assistance to other sites historically on request as part of that network. The CasePro network, some of you have been a part of it for a while. It was born out of COVID, really, and the large backlogs that were growing in courts and in the justice system. And because JMI does a lot of work in the area of case processing and case management, we wanted to create a network and a space to bring practitioners together to talk through some of the challenges that we face, to identify some promising strategies, and really just, provide you all an opportunity to learn from each other. So this is our last, I think, Robin, mini institute. And, historically we've focused on more serious criminal cases, felonies and misdemeanors. But, probation cases are ones that we often overlook. And there are a lot of those types of cases that come into the system. And what we know about, the deterrent effect of the threat of sanctions for noncompliance is that it is only as effective as it is as, okay, I needed more caffeine this morning. It's only as effective as it can be when those sanctions are swift and certain. And the one thing we know about courts right now is they're not necessarily swift or certain. So I thank you all for joining us. I'm super excited to hear from our panelists and to hear from all of you. And I'm going to turn it over to Jesse Janetta, who runs the Probation Network.
Hi, everyone. I'm Jesse Jeanette. I'm a senior policy fellow at the Urban Institute. And as Elaine said, along with Walter Campbell, who's here, I'm one of the leads for the Probation Peer Learning Network that we've been facilitating as part of the Safety and Justice Challenge. And there were sort of 3 main things that we hope to accomplish by having a probation network exist in the SJC. One was to provide a forum for probation professionals and their partners to exchange knowledge and share practices that they have been doing that could safely reduce the use of jail as a response to violations of probation, and using that to sort of find opportunities, not unlike this one, to feed some of that knowledge and thinking into the Safety and Justice Challenge. The idea when we were creating the probation network was that relative to some of the other partner and justice agency communities that were part of the SJC, that probation had gotten relatively less attention, certainly compared to how important it was, and also that more probation thinking in the SJC could be very valuable because probation as a profession is such a strong source of understanding of evidence-based practice and innovative thinking. And then the last thing that we wanted to do was use it as an opportunity to invite new partners and new jurisdictions into the SJC network. And I'm very excited that our partners from Brazoria County, Texas, was one of the most recent communities to join the network, is represented here alongside the great faculty that we have in general. And when you hear from them, I think you'll see why there was so much value in doing all of the things that I was describing, because there's so much creative and innovative and thoughtful work being done in Brazoria. So excited to play a part in sharing that with you all. And
Thank you,
then I can get
Jesse.
back to you, Robin.
And thank you, Elaine. Okay, so a little bit from me. I'm going to be sort of the MC throughout this presentation, and to give you a little bit of a preemptive introduction about how we're sort of running this. One of the things you might have noticed is we did not set this up as a webinar, and that was intentional. We really want to have a collaborative experience over the next hour and a half. And so the main ways we're providing for that are we will be using polling questions, but also the chat is open, and the chat is a place whenever you want, whatever you want. Please feel free to use it, ask your questions, offer your own experiences. All of the faculty and all of the rest of you as well are encouraged to respond to that chat. It's almost like we'll have two webinars going on at the same time if we get really active there. We'll have what's going on the screen and hopefully a really robust conversation in the chat as well. So that is sort of the main ways. Also, it's a way for you to perhaps ask questions that maybe we won't have time in the official presentation to get to them, but you will get your questions answered, because one of the great things about these networks, both the CasePro and Probation, is we all have amazing experiences, right? And we all have things to offer. So this is really supposed to be a collective session. All right, let's get going. Okay, so in that collective nature, the first thing we're going to do is we're going to get a sense of where you all are calling in from. So if you could left click the little circle with the pencil in it, usually it's in the bottom left corner, then left click the fifth symbol down, which is that arrow. You can see a picture of it. And then hold down that left arrow or that arrow and drag it to where you are on the map. That all makes sense for everybody? So hit the little dealy bop, the circle. Oh, you guys are doing great. Nice. So that kind of gives us a sense of where we're all calling in from. Anybody have any struggles with that? It looks like y'all are getting it done pretty well. Great. Okay, so I have one more question just to give us a sense of sorry, multitasking here, of where we're all how we're all associated. So we have the first question of the day, which is, and this was the question you actually answered when you registered, but I thought it would be fun to answer it again, because of course, you know, people register don't get a chance to show up. So the question is, in what agency do you work? I'm going to launch that poll for you. If you could please answer that. Okay, I've had some of you answer. Almost there. All right, we've got 80% that have answered. And then if you haven't done a poll in Zoom before, I'm sure you all have, but once you make your selection, just make sure to hit the submit button at the bottom. All right, let's see what that looks like. All right, so hopefully you can see that. Not that much different from registration, really. The bulk of you are coming from the probation department, but we also have the judiciary present, nonprofit organization, of course, and a smattering of others, as you can see from that chart. So thank you for that. All right, let's get to some fun stuff now. Sorry. Ugh. Transitioning. So fun. There we go. Okay, so now we're going to do some quick introductions of all of our faculty. Walter, do you want to start it off?
Sure. Hi, everyone. Walter Campbell. I'm a senior research associate at the Urban Institute. And as Jesse mentioned earlier, we co-led the Probation Network. Pass it to you, Gabby.
I'm Gabby Hillman. I'm a program analyst with the Justice Management Institute.
Caitlin?
Hi, everybody. Happy Friday. My name is Caitlin Flood. I'm a manager at the Crime and Justice Institute.
All right, Maricopa, it's your turn. I don't know, Sean or Nicole, which one of you wants to go first?
Hi, good day, everyone. I'm Nicole Garcia with the Superior Court of Arizona in Maricopa County, and I am the Criminal Department Administrator. I'm going to pass it to Sean.
Hello, everyone. Sean McMillan with Maricopa County Adult Probation. I'm a division director, and within my division is our court liaison unit, which serves our probation violation courts.
Fantastic. And then last but certainly not least, Kara and Carla.
Hi, I'm Kara Turner, one of the deputy directors here in Brazoria County, and that's south of Houston in Texas.
Hello, Carla Cooch, also Deputy Director here in Brazoria County, Adult Probation.
Awesome. Thank you, you two. Okay, so this presentation is sort of three parts. We've got a little bit of a preview about who is on probation. This is looking at national statistics and kind of giving you a sense of that. And then a little bit of a discussion about what setting realistic and appropriate conditions looks like, just a brief overview. And then the big part of our time today will be spent on characteristics of high functioning probation departments and docketing practices. And that's where we'll have our Maricopa and Brazoria folks really talk about some of the things that they're doing in their jurisdictions. So let's talk about who's on probation. Walter?
Perfect. Thank you, Robin, and hi, everyone. So yeah, just as Robin said, I'm going to give everyone sort of a general overview of probation across the United States, and some of the trends therein, just so we get a better sense of the population. So this the figures I'm presenting all come from the Bureau of Justice Statistics, which collects probation and parole data from across the country. And you can see here, this is the trend over sort of the last 10 years of data collection, at least by their most recent data. And generally speaking, probation was sort of decreasing or the probation population was decreasing across the 20 teens, and then post-pandemic, though, has kind of started to jump back up. This should also be noted in contrast with some of the trends in incarceration, which have just generally been decreasing and saw a much bigger decrease post-COVID. And so again, just sort of the relevance of probation here. There's a lot of people on probation. That population hasn't changed a ton, and it actually seems to be a bit on the rise of late. In terms of who's on probation, the population generally reflects what we see at other stages of the criminal justice system. That's reflected here. It's about three-fourths males on probation and one-fourth female. That's fairly similar to what you see for incarceration, for jail, for prisons, etc. And then in terms of race and ethnicity, about half of the folks on probation are white, about a third are Black, and 16% are Hispanic or Latino. And so, and one thing to note here is that the share of Black individuals on probation is much larger than their share of the total U.S. population. So it's about double. So this is sort of an overrepresentation there, and then an underrepresentation for white folks. Again, kind of reflecting what we often see in prisons and jails as well. For type of offense, it's much more evenly distributed on probation than you might see in prisons, which tend to be far more violent offenses and far fewer property and drug offenses. Here you can see it's almost an equal divide of about a quarter here for each, and then the piece that's missing here is about 20-ish% for sort of public order, other types of charges. So a wide range of reasons people are on probation. And then finally, and I think this is the piece of the national picture that's maybe most relevant to what we'll talk about today, but is only about a little bit over half of people on probation end probation successfully. And so again, I think a lot of the stuff we're talking about today are things that are designed to improve that overall number. About 15% end in incarceration. 7% end in some other unsatisfactory completion that does not involve incarceration. So this might be sort of a technical violation or revocation that results in a new community supervision sentence, but not an incarceration or something along those lines. And then 18% end in some other way. This covers a whole range of things, but includes things like death or other miscellaneous ways that probation might end. With that, I'm going to turn it over to Gabby to talk a little bit about some figures from the states you all are from.
Thank you. So for this graph, we showed the number of people on probation per 100,000 adults as of December 31st, 2022. And we pulled this information from the same report that Walter just spoke about. And so we pulled the 14 states of participants on this call so you can kind of contextualize yourself of how your state compares to the other states of people on this call. And just for context, and this is per 100,000 people, so it was to level the playing field of comparisons here. And so the highest state within this entire chart, or of all the states, was Georgia, and they had 4,169 people per 100,000. And then the lowest state was New Hampshire, which had 333 per 100,000 people. So we thought it would just be a helpful way to kind of see how you compare on the state. And if you're interested in kind of diving deeper in to the rest of this data, we will share that in a resource guide that I'll talk a little bit more about at the end of this call. But there's definitely some other information that might be helpful where you can compare your specific county to the state data. So
Thanks, Gabby.
thank you.
All right, so now we get to talk about setting realistic and appropriate conditions. Caitlin, are you ready?
Yes, thank you, Robin. Awesome, thank you. Again, Caitlin Flood, I'm a manager at the Crime and Justice Institute. And just to give some context as to how the Crime and Justice Institute got involved in the national standards, a little bit of the trajectory here is that APPA, as you all know, American Probation and Parole Association, had been working on the standards from about 2019. And they kind of tasked themselves as the national coalition and working group for all things evidence-based practices with probation and parole, tasked themselves with producing national standards for community supervision. This project was started in 2019, and Crime and Justice Institute wasn't initially involved in this, but we were fortunate enough in partnership with NIC and APPA to then get involved in late 2022, early 2023, to really help this work group finalize these national standards. The work group was composed of national supervision experts, so folks that had previously led supervision divisions, so whether that was probation chiefs, current and retired, as well as former parole board members, parole chairs. And the task of this work group was to bring expertise from across academic research, really highlighting evidence-based practices, and kind of bridge some of that research and make it more accessible or action-oriented. So this group of practitioners, leaders in the supervision field, and then researchers came together. And from 2019 till finally 2024, when the standards were published, they went through, and we had about monthly meetings where some of the greats in community supervision came together to kind of talk out, how do we create a set of standards that are both comprehensive in laying out evidence-based practices while also being timely, right? Because we know when we're trying to produce evidence-based practices, putting pen to paper sometimes means that we are not capturing the most up-to-date research or pilots or evaluations. So what this group did was they outlined 11 standards, and each of the standards has commentary that provides, links and resources to kind of justify and explain particular standards of policy and practice. These standards are meant to be aspirational, as you can see if you've ever paged through the document. I think it's upwards of 300 pages. And what the work group really was prioritizing was, how do we give a list of standards that are both aspirational, but also creating some realistic benchmarks or milestones for busy community supervision leaders and staff. So we have these 11 focus areas, and they cover all of the things that you all might anticipate, and would certainly encourage you. This resource lives on the APPA website, and it's covering things like caseload standards, and the differences between a workload analysis and caseloads, and using different risk need assessments. Thank you for the note, Robin. I'm probably talking way too fast. So you're giving me we know you're from New York, but slow down message. So I appreciate you. And so these topic areas probably could be condensed even further into, different theme areas, but the work group found that it was important to give time and space to the whole trajectory of setting supervision conditions, and really covers the gamut from who are the decision makers that are initially setting supervision conditions, whether that's the paroling authority, so the parole board, the judge in the case of probation, all the way through condition enforcement, right? So giving some guidance and standardizing best practices for supervision officers, and then kind of ending at the either successful or unsuccessful termination of the supervision term. And to Walter's point, as all of you know, within the community supervision space, there has been very recent attention, especially in the last 5 to 10 years, about high revocation rates. And so what the standards also tried to accomplish was giving practical evidence-based recommendations and research to improve supervision outcomes while also reducing revocations from supervision or unsuccessful terminations. The two standards that I wanted to just kind of point out as probably most relevant and realistic for this conversation, and where we've gotten the most amount of questions, is standard 2, which is sentencing to probation and parole. So again, this is kind of starting chapter 1 of probation and parole, which is who are setting these initial conditions and what information do these decision makers have at the time that supervision conditions are being set. And what this national work group of experts came to, and what we were seeing in the research and a lot of the evaluations covering supervision conditions, was that there's a wide gamut of the type of information that initial decision makers have in front of them when setting supervision conditions. And we might assume as supervision practitioners or researchers that judges or parole board members have in front of them an updated risk and need assessment when setting conditions. However, what the work group came to, and in speaking with different supervision agencies, what this standard highlights is that best practice should certainly include updated risk and need assessments in order to set conditions, but that is not always the case. And so there's some recommendations around how to improve the inputs for decision makers setting these conditions, and for supervision agencies to consider how to streamline or tailor individualized supervision conditions that actually align with risk, need, responsivity factors. So that's standards 2, kind of the beginning of what conditions are we imposing on folks and are they realistic? And then standard 10, looking at influencing behavior. And this standard really covers how officers and how supervision agencies are able to do the work of impacting and informing long-term behavior change. One way in which we know that officers can do that is by enforcing in fair and equitable ways supervision conditions. But in this topic area, we also cover things like graduated sanctions, supervision agencies that have like a standardized matrix of responses to either non-compliant behavior resulting in sanctions or positive behavior resulting in incentives, or what some agencies would call rewards or positive reinforcements. So the standards document itself, pretty long document, but would definitely encourage all to reach out to APPA if there are questions. And just as like a quick teaser, in 2026, there will be a follow-up document that's being published that is a streamlined guide for supervision leadership on how to kind of align standards and what's in the document, but making the document more actionable and doing a compare and contrast to supervision agencies' own policies and practices and how those align or depart from the standards. Next slide, please. Thank you, Robin. And so one resource that we kind of just wanted to give a shout out to, and this will be familiar to probably a lot of folks on this call. So Pew has obviously done a ton of great work in this space, specifically outlining some recommendations of how current supervision practices can better align with evidence-based practices. So this report, which I believe was released in 2020, is still super relevant today. And this Pew resource has really served as either the basis for a lot of other work that CJI and others have engaged in. Specifically, the Crime and Justice Institute took both some recommendations from this Pew policy reform brief, and then some of our own interactions with 4 different supervision agencies to build out system assessments that looked at revocation rates, so reincarceration rates where supervision was terminated unsuccessful. And we highlight the Pew resource, both to say there's a lot of great information, citations, and assessments that are cited to in this Pew resource, but also to highlight the bridge between the barriers, the areas of improvement, the gaps that Pew is pointing out in the current supervision field, and then how the standards can help either fill some of those gaps or provide additional guidance to practitioners. So some of the main areas and kind of the pain points that all of us have experienced either as practitioners or folks that are working kind of on the back end and looking at recidivism revocation rates. Pew is outlining here alternatives to arrest or different responses to non-compliant behavior, non-compliance with supervision conditions. They outline different ways that evidence-based policies can actually refocus on risk and need tools, and how risk and need assessments are informing case plans. They provide, different recommendations around either from a policy or legislative lens, how supervision sentences can be streamlined, or where legislation can be in place to establish some type of second look mechanisms to maybe reconsider very long supervision terms, or to reconsider and modify expansive and maybe duplicative supervision conditions. So just a plug for this great resource, and that this resource was considered as the standards were being put together. I think this policy reform brief kind of really laid out the problem statement and some recommendations, and then the standards took that resource and said, here's some additional research and commentary from the experts in the field, both at the practitioner level and the research level, on how supervision agencies can use the standards resource to better align with up-to-date evidence-based practice.
Thank you, Caitlin.
Sure.
Okay, so you heard all that, particularly about the APPA standards. So we wanted to ask you a couple polling questions about that. So we've got 2 for you. And you should now see them on your screen. The first one, before today, were you aware of the APPA standards? And then 2, is your probation department using or considering using, even if it was just right now after this presentation, the APPA standards? So. Okay, we've got about 40 people who've responded. A few more. Okay, I'm going to close the poll and share the results. Fantastic. So a majority of you had heard of the APPA standards, so glad to put it in front of you again today. But a few of you had not, so that's good. So it's really a good resource, and I think, as we all know, especially those of us who are working on these sort of systemic issues, probation issues aren't just about the probation department. So I really encourage all of you to take a look at those standards. There's a nice summary sheet that you don't have to read the big fat document, so that's helpful too. And Gabby will talk about this at the end, but we'll provide links to both the full standards and the link to the shortened version. And then, yeah, that's great that a lot of you are currently using the standards. And yeah, so thank you for those two answers. All right. All right. So now we get to hear from Maricopa and Brazoria. So we are going to start out with Maricopa talking about responses to probation violations. So Nicole and Sean, take it away.
Hey everyone. I'll kind of get started with an overview of Maricopa County adult probation. I think Nicole later on will kind of get into like the rules that kind of guide our PV courts and the types of hearings we have and our turnaround times and our docketing practices. So here specifically in Maricopa County, I think most of us as part of pretrial or probation agencies would say like one of our goals is community safety. With Maricopa, we think one of the ways we can best support that is using evidence-based practices to try to facilitate and encourage long-lasting behavior change with those while they're under our supervision. And so some of the ways we do that is we use a risk needs assessment to kind of gauge individual needs, risk in the community, and kind of get our case planning around that. Try to use targeted interventions. Something people hate, like one of the words that people hate the most is role play. So we like to say we like to use skill practice and directed practice or deliberate practice to kind of remove that scary role playing word from the process. We obviously engage our community partners for social support services, whether that's employment resources, housing, treatment, mental health services, while individuals are in the community. And then obviously we have a dedicated data analytics team that kind of looks at our success rates and our strategic agendas to make sure we're kind of doing the right things to ensure success as a department. And Robin, if we can go to the next slide, thank you. So part of our individual approach to supervision is whenever we have somebody that's showing positive or aggressive behaviors, we're going to try to approach that with a graduated response, right? That fits the behavior that's in front of us. It's not just every problem is a nail and our only tool is a hammer. We really try to meet the individual where they're at based on their needs. And that includes positive and regressive behaviors, like I said. And we really think those should be tied to the case plan and that individual's needs. So we use that risk assessment to kind of develop a case plan based on that individual's needs or their risk or their goals, right? We also try to take into consideration the stage of change that they're at to ensure like we don't have somebody that's in the maintenance stage and we're kind of just inundating them with a bunch of stuff to address like a small lapse in behavior. And so we try to take that all in consideration. Some of the things that we have examples of both positive and responses to both positive and regressive behavior. I won't list all of them, but some of the things that we have on the positive side, it's kind of just that verbal positive recognition. We can obviously tailor our supervision practices within our policies to ensure an individual, we're kind of meeting them where they're at. So if we have somebody reporting very frequently at the beginning of probation, but then they're showing a lot of progress, maybe we taper off that supervision and maybe supplement it with some virtuals instead of having that person drive in and see us in person. Also, like through community resources, we'll try to get bus passes to ensure people are making it to treatment, making sure that they are making all their court hearings, that sort of stuff. We can obviously tailor like supervision practices as well to kind of meet people where they're at. So if we have somebody that's struggling with substance use disorder, maybe we can get them, screen them for eligibility for our DUI or drug court programs. And then we also have responses, obviously, to regressive behaviors as well. We try to do our skill practice, use our cognitive tools, like anybody familiar with carry guides, BITS. Those are some of the tools that we use in our agency. We also do our own in-house cognitive behavior programs that we facilitate with our staff. And that's called Thinking for a Change and Decision Points. And so we train our officers to be able to facilitate those classes for individuals under supervision. And then we can also if somebody's on like our standard probation caseloads, but they're showing some behaviors that we think might warrant intensive probation or another specialty caseload like domestic violence, sex offender, or severely mentally ill caseloads, we can screen people for those and make modifications to try to get them on those caseloads that might serve them better. And then obviously we can do increased reporting. Our goal is to really exhaust both on the positive side and the negative side, like all the graduated responses we kind of have at our disposal before we look at any higher level interventions. And specifically on that regressive side, that next step intervention is going to be court intervention. And so if we do kind of exhaust all of our graduated responses, they're not resonating, or somebody is not engaging with probation, we do have that next step when we can file what we call a petition to revoke probation and have that person be brought in front of our probation violation court. And with that, there's kind of 3 lanes that somebody can be brought in front of probation violation here in Maricopa County. The first being through summons. So maybe this is an individual. I think a common thing that I see is on DUI cases. Let's say somebody gets cited for a DUI, but our local agencies decide to what we call long form them, and those charges might come back up a year, 18 months from the date of offense. In that 18 months, maybe that person is engaged in probation on another case, they're doing really well. And so maybe we want to do a summons to court. Like, we don't think that person should be in custody at that time, but they probably do need court intervention to address that new charge that has now been filed. Then we have our warrant process. So that's for somebody, that's not engaging with probation. We can't locate them in the community. So we're going to look to file a petition to revoke with a warrant order. That way we can send that to our fugitive apprehension units to try to locate that person in the community and get them back re-engaged and in front of probation violation court. And then the third option we have is what we call a warrantless petition to revoke. So let's say we just see an immediate issue when we're doing a field visit out in the community. There's risk to a victim or community safety. We may facilitate an arrest there on the scene and then file what we call a warrantless petition to revoke and bring that person to probation violation court. So once we get to probation violation court, that's kind of where my division comes in play. We have, like I mentioned earlier, a dedicated unit of officers and support staff housed within our probation violation court. And so they serve and support the 3 courtrooms we have for probation violation court. We call it the court liaison unit. I like to say it's CLU, CLU as the abbreviation. So that dedicated team, some of the things that they do for the court and for our officers is, given our volume of people on probation and the volume of cases we see come through probation violation court, it's almost impossible, or probably would be impossible, to ask every officer to attend all their hearings for people on their caseloads. Years ago, we used to have probation officers assigned to specific courtrooms, as well before my time, but it's just not the reality that we live in nowadays in Maricopa County. So the court liaison kind of serves as that liaison for the field officers to kind of be their representative in court, but they also are checking the petitions and the reports that are coming through to ensure field officers are making justified legal recommendations, that it's aligned with best practices, those sort of things. And so one key role that they really play on that side is a lot of guiding and developing field staff, educating them on what are the rules, codes, and statutes that kind of guide what we can recommend, and really making sure we're in alignment with our mission, vision, values of, are we recommending the things we should be to get that person re-engaged with probation and keep them in the community as long as we can. They're also prepping everything for the court process, so that way all stakeholders in the court have access to all the information being provided by the probation officer. So that ensures, like, they're reviewing the calendars, making sure revised expiration dates are accurate, days in custody are accurate, those sort of things that kind of help keep the court process moving pretty quickly. They're also present in every day in one of the courtrooms. So we have 3 courtrooms, and there's a court liaison officer in each of those courtrooms every day. I should say Monday through Friday. And so when it's appropriate, they'll speak into cases if there's questions from attorneys or from the bench. They'll also meet with individuals in the courtroom and try to give them some written directives. of what they should be doing right after court. So if it's a reinstatement back to probation, they'll inform an individual, hey, you probably want to call your officer. Here's their number. Here's the office they're located at. And maybe here's a couple other things they want you to do: enroll in treatment, complete an intake, those sort of things. And so that's the biggest process the biggest part that our court liaison officers play in PV court.
Thanks, Sean.
Yep.
All right, so now we get to hear from Brazoria. Kara,
Hello.
let's go.
So yeah, a lot of what Sean was actually talking about, we do a little bit similarly in how we exhaust all of our options, and we have progressive responses that we go through and stuff like that. We did, like Jesse and Walter mentioned, start with some technical assistance and try to look at reducing our jail stays. And so to do that, we started looking at, okay, what can we do, real quick to work on this? And we looked at our progressive responses and how we were responding to, like it says, certain violations, technical violations and new offenses. Can you go to the next slide for us? One more, sorry.
I was just like, do you want me to go one more?
Yeah.
There we go.
Yeah. So we'll start getting into some of those examples. So
Yeah. So in the past, whether it was a new law violation, could have consisted of anything from a Class B, like driving while license invalid, to Class A or even felony, we had a practice of filing a motion to revoke no matter what that offense was. If it was a new arrest, we filed a motion with the district attorney's office. The warrant was issued. The individual was arrested. They would have to wait in jail or bond out until a court date was set, no matter what the recommendation was. So, like Carla mentioned, and to reduce the jail stays, we started looking at, can we handle things differently, and kind of expedite the process. Usually whenever there's a new law violation, there's something going on with the individual, and we need to identify like resources or needs that we can assist them with in order to change that behavior. So now, if the probation recommendation is not revoked, or if the new law violation is not a felony, a DWI, or assault, the officer has the discretion to stop that case and take it before the judge with the recommendation. Maybe the recommendation is for treatment or classes. Just need to approach the conditions differently. We can go immediately before the court and provide our recommendation for the judge to consider amending the terms and conditions. But unfortunately, if it's still a new law violation, that's a DWI, assault, or felony, we still go through the process of filing the motion and letting that warrant and arrest take us to the revocation hearing. Next slide.
So yeah, another example, some of our other violations, our technical violations, we wouldn't automatically, of course, respond in the past with just submitting a motion to the DA's office automatically. We would always, go through our process of figuring out what's best and trying to help. But one thing that we have switched up a little is, for example, with our drug testing, if a person comes in and says, you know what, it's going to be positive, like I used, and they come in and admit and they kind of tell you what's going on, we're going to respond, and we've changed it up a little where we're not going to say, well, you know what, this is a violation, let's see how we're going to respond that route. We're going to go therapeutically and say, okay, what are our treatment options? Where can we help this person? Where, do we need an updated assessment? What's the next step in treatment? And go that route instead of automatically, tallying this as a violation and go in that route. For other violations, we have other things in place also. I mean, we're going to always try to get to the root of the problem. We're going to discuss it. We're going to try to build a little bit of rapport even with this person to see what is going on. Where can we help? We're not going to just, jump to letting it go on for a couple months, 2-3 months, and then say, you know what, that's it. You're not reporting, or you're not able to pay. You're not doing these classes. And after a couple months, just say, we're done. And like Kara was mentioning, submitting a motion, which results in a warrant, and you waiting to have to go to jail and wait for the the hearing. So we'll try to, dig deeper and find the root of the cause and see where we can help and what resources we can provide. So that's a little, different way that we've gone through there. So can you go to the next slide for us?
So, but with change comes challenges. And not so much newer staff, but some of the tenured staff, it was hard for them to wrap their mind around not going straight to court, not filing that motion. But having the opportunity to talk to people and tell them the reasoning behind it, why, like if the ultimate goal is to get these individuals help, then we want to go the fastest route to get the individual what they need. But again, they see it as sometimes, they're still using, and why is that not considered a violation of their court order? But at least that individual in some instances is being honest and upfront, and we can take that as, hey, it's a cry for help versus a violation kind of thing. So that was the biggest challenge, is just, and still sometimes, is to get those officers and supervisors wrapped around, hey, let's look at it differently, come at it at a different angle. Next slide.
There is a question that came up that I thought might be fun for you guys to answer.
I did see the question. So, and I was gonna wrap around, of course. So yeah, and of course, like there's challenges with change. There's challenges. There's, the advantages that we of course looked at is more swift responses. Fewer people getting arrested, fewer people going to jail, and just building that rapport between officers and the individuals. And them really understanding each other and how can you help me, and them being able to come in and say, you know what, you're not here just. You don't just want my money, or you're not here just to put me in jail or to catch me. You're here to help me, and that was our ultimate goal. So yeah, to wrap around to the question. So if a person comes in and they say, you know what, I'm going to test positive, I'm going to do this. We do have them sign an admit form. So if they admit, we don't have to. In some occasions, we do have them go ahead and test anyway, just to see if there's anything else going on. Maybe they're, admitting that they drank alcohol because they're scared, but we suspect that there's, maybe more serious use like meth use or something like that. It'll kind of depend on the officer. They have a little bit of discretion to kind of see what they get from that person. But if we do have an admit form, I mean, for us, it doesn't, I mean, you're admitting that you're using, so we're going to treat it as a cry for help, like Kara mentioned. So regardless of really what it is, we're gonna respond the same.
And there's another question about the stakeholders, the court and the DA, and changing in policy. And they're actually supportive and on board. Of course, the director, Dr. Dillon, we had meetings with them and talked through scenarios and options and just how to approach it. But I think whenever you look at ultimately what the goal is, and the goal is to identify the needs and services and get the individual routed in that direction as fast as possible, then that's what everybody's on board for that outcome.
And I think it was really, really beneficial and amazing here that with our county, we have a very good relationship with our judiciary. We have a very good relationship with our DA's office. So it's usually, yes, there's always conversations, but it seems to be very easy conversations. They have trust in us. They respect our opinions. And so it's usually good for us here.
Thankfully, yes.
Oh, well, yeah, we mentioned, the fewer jail stays, and just seeing how that the people can grow together, the officer helping the individual. So next slide. Thanks.
Yeah, I pulled up that slide and I was like, man, I'm like at about a B-, maybe C+ right now. So I'll work on that. All right, so we've got a polling question for you. The question is, do you think your jurisdiction's probation department generally handles probation violations effectively? Okay, we've got 30 responses. Okay. I'm going to shut down the poll and share the results. So yeah, so the majority of you, if you count 4 and 5, so 41 plus 17, do think that your probation department is generally handling probation violations well. So that's fantastic. There's a few of you that are kind of in the middle. at 27%, and a few that think that there's some more work to be done. Does anybody want to talk about their answer or offer anything about your own probation department?
I just will say that I chose 4 because while things run pretty good, there's always room for improvement, and so always being open-minded to it.
I think with us, and this is Deborah Wright with Community Corrections in Lawrence, Kansas. I think with us, sometimes it gets frustrating. Start my video here. Sometimes it gets frustrating when we receive or clients are assigned to community corrections that have those criminal history A's and B's that pose a risk to the community. They're still assigned to community corrections based on a departure, but there's so many chances that are given in court when they continue to violate their probation. I think that's where it gets frustrating for us. And so we just continue to do the work that we do with them. But that is frustrating because they're already presumptive prison when we get them. Some of them go AWOL, some of them pick up new offenses. It's just difficult to work with those clients. And then on top of that, they're either there's a mental illness, there may be alcohol and drug issues, they're homeless, there's continued violence, and that just makes it difficult. So,
Does anybody else want to offer up their answer for the polling question or share anything about their probation department?
This is Commissioner Boyle with Maricopa County, speaking on behalf of myself and Commissioner Mitchell. I mean, we just have a lot of praise for the probation department, what the probation officers do. I mean, from top to bottom, I just think people are working professionally in often very difficult circumstances, but I mean, going out of their way to try to find the people in the community. We struggle, obviously, a lot of our people on probation struggle with homelessness. Probation officers go out, try to find them, are asking questions and really trying to meet their needs with where they are. And so we also recognize, though, we're the ones seeing the probation violations, that there's a lot of really good work that happens that we don't get to see. So again, just overall, we're impressed and happy to be a part of the probation department or working with the probation department in that sense.
Great, thank you. Okay, so we are going to go to the second part. And just to give you guys a little context, what we were trying to do here is obviously talk about probation departments and what probation departments are doing and some of those innovative practices. And then switching to really talk about probation violation dockets. I don't know if it's the case with anybody on the call right now, but if you look at the landscape nationally, a lot of jurisdictions have struggles getting these probation violations back on judges' calendars. For example, in a lot of places, the process is that the same judge who sentenced the individual is the person that hears the probation violation, and perhaps they can't get the person on the calendar for 30 or more days is not uncommon. So we really wanted to talk about a couple of innovative practices that Maricopa and Brazoria are doing. So let's get to it. So back to Maricopa. Nicole, is this you?
This is me. Okay, so in Maricopa County and really the entire state of Arizona, our probation violation matters are governed by the Arizona Rules of Criminal Procedure, specifically Rule 27.8. And the rules dictate the timeline within which we must set the hearings after a violation occurs. And I want to preface this by saying that our probation department has done a lot of work to make sure that these are not like necessarily ticky-tack, what we'll say, violations. So it's not like, oh, you didn't provide us your address, we're gonna file a petition to revoke on you. They have really done a lot of work to get us away from that practice. So the people who are coming into our probation violation courts, these are more serious, I'll say, or solid actual violations. They're not like ticky-tack violations. So a petition to revoke is filed by one of our probation officers, and then that person either is picked up by adult probation or by one of our law enforcement agencies, or they are served a summons. And then for those who are picked up, they are brought to our initial appearance court, which operates 24/7, 365. And they have an initial appearance hearing. After that initial appearance hearing, they must have a revocation arraignment with our probation violation court. And that is, by rule, it has to occur within 7 days of the initial appearance. And again, I realize Maricopa County is big, so not everyone has a 24/7 initial appearance court, but we do. And so we are setting probation violation matters throughout the day and throughout the year. After the revocation arraignment hearing, or let me back up. At the initial appearance hearing, our initial appearance court will schedule the revocation arraignment hearing on the calendars of our probation violation court. We have moved to a model where we have a standalone separate docket or dockets for probation violation matters. In our county, and this is not reflective of the rest of the state of Arizona, but in Maricopa County, we have 3 calendars that hear nothing but probation violation matters. That has been in place at least more than 20 years, I want to say. I've been with Maricopa County for 20 years, and we have always had probation violation dockets in that time, so it probably predates that even. So we have moved to that model because we found that it was easier to get probation matters docketed if there were a dedicated calendar for these, rather than trying to have to find space on a judicial officer's calendar that was within the rules. And so, by having these 3 dedicated calendars, there is likely always availability for any of the number of probation violation matters that we must schedule when somebody violates. There's also a benefit of having somewhat consistent practices between the 3 judicial officers who are hearing all of these matters. And, that's not to say that they all do everything exactly the same, but they are pretty much operating somewhat similarly. And then they have a dedicated staff who is able to provide the support that they need to have these kind of matters and to hear these kind of matters. So after the revocation arraignment happens, then we have the violation hearing, and that is where the CLAPO, or the court liaison adult probation officer that Sean mentioned, that is where those officers are involved. The violation hearings are held within 7 to 20 days after the revocation arraignment happens. And at that time, that's more of the evidence portion. So, is this what actually happened? What is the evidence that the violation occurred? And it's an evidentiary hearing. So both sides, they can present and they can cross-examine and question. If a violation is found to have occurred, then the court has to make specific findings, and then a disposition hearing is held. And that is within 7 to 20 days after the violation is found. And the court can revoke at the disposition hearing. The court can then revoke probation. They can modify the terms of probation, or they can reinstate probation. And revoke, they can convert it to a prison sentence. I don't know if usually there's a jail term attached with a revocation, but generally I think it's revoking to prison. And if it's revoked, then the sentence that could be imposed is imposed. And again, going back to my point about violations not being ticky-tack violations, if a condition of probation was not provided to the defendant in writing, and the defendant then goes and commits something that an officer believes to be a violation, the court cannot count that or find that as a violation. The state of Arizona has done a lot of work around our conditions of probation. We have, within the last 2 years, the state of Arizona has moved to uniform conditions of probation. So all of the terms of probation that exist, or the types of probation that exist in Arizona, are the same throughout the entire state. And we have even gone so far as to make sure that they are presented in the same order, that they are grouped in the same categories, and that the form that they print out on even is the same. So again, we've done a lot of work to make sure that they are easy to understand and that the defendant is able to understand what is being asked of them as part of their terms of probation. And in the chat, somebody asked how many people will admit to violating the terms of their probation. And Commissioner Boyle noted that well over 90% of the individuals admit to violating the terms. So, yep.
Two things to mention. In the chat, we put the rule of procedure, if anybody wants to take a look at it. And then Nicole, would it be possible to share that uniform list with us?
Yes.
In fact, if there's a link, we could throw it in the chat as well. And y'all have heard this already, but Gabby's going to talk about this at the end with the resource list. We'll make sure to put it in there as well.
Yes, we will make sure to get that resource to everyone. So moving on to a little bit of specifics about our probation violation court. We currently have 3 dedicated dockets with 3 commissioners, Monday through Friday from 8 to 5. Adult probation, the indigent defense, and county attorney, they all are present for all of the hearings, and they all have, because these are, they have become kind of like standardized in how at least the process of the hearing is going to flow. We have generally staffed defense and county attorneys who are present at these hearings, meaning it's the same defense attorneys and the same county attorneys who are going to appear in the courtrooms that we have. As I said, we currently have 3 dedicated courtrooms. Over the years, that has fluctuated. We previously had 2 courtrooms. Within the last year, we moved to 3, but there have been instances before that where we have had 3 or even 2.5 dockets. Most recently, we moved to 3 calendars as a result or a downstream effect of the COVID-19 pandemic. A lot of matters were delayed during the pandemic, and we have a high volume court in Superior Court. We call it our early disposition court. And the cases in those are usually lower level felony offenses, and they're typically not going to have long prison sentences. At most, it may be like a 5-year prison sentence, but most of the results of the early disposition cases are going to be probation matters, diversion, or jail with a probation tail. And so as a result of the pandemic, things got bogged down. And when things came back to normal, we had a huge glut of cases, and we started calling it the egg and the snake, because we just had all these cases that needed to be heard. The county attorney resumed their normal summonsing and charging practices. So it was just a balloon of cases. And we were able to resolve those cases and kind of get back on track. But then what that did is move the egg farther down into the snake. And so about a year later, we started seeing a really dramatic spike in our probation violation matters. And again, we had 2 dedicated dockets at that point, and both of those dockets were having 100+ matters daily, Monday through Friday, 8 to 5, 100+ matters. There were days when the number of matters was in excess of 120 matters per docket. And so we moved some resources around, and we were able to add a 3rd docket. We moved 1 docket out of a different area of the criminal department, and we restructured that into another probation violation calendar. And so we were able to bring the number of daily matters into a much more reasonable, although still high volume calendar. And now we have, I mean, if you can just imagine 120+ times 2, now it's divided by 3 judicial officers. And they do monumental work. And I'm not just saying that because I have 2 of them on the call. They really do do a lot of work to meet people where they are, and to treat them fairly, and to give them time with their matter, and at the same time go through the number of items that are on their docket every day.
That's still a pretty high load, to be honest.
It is. I have tremendous respect for them.
I also have to comment, I'm absolutely grateful for the new phrase I just learned today. Thank you, Nicole. The egg that moved down the snake. That's a good one.
My presiding judge and I said it so often in the first 2 years after we resumed normal operations that we joked we were going to get a tattoo of a snake that had a big bulge in the middle. So yeah, that phrase is ingrained in me now.
Tim and Elaine and all of my other TA providers on this call, I think we might have to use that phrase. I might be in love with it.
I agree.
All right, Brazoria, let's talk about your probation violation docket.
So Brazoria is definitely not the size of Maricopa, because we only have 11 judges, which consist of 5 felony courts, 4 county courts, and 2 associate judges. But in the event someone has a motion to revoke or motion to adjudicate filed, the judges try to plan out their dockets and have like revocation hearing times. They are kind of mixed in with other criminal hearings, but it kind of gives us an idea, or the court administrators an idea of when to set these cases back before them. Typically misdemeanors do get reset back on the docket before felonies do, but these dockets are an opportunity for the probation department to have a recommendation and share that with the court. And then ultimately the judge can determine any amendments, modifications, or revocation to the county, state, or unfortunately prison. It just depends on, the circumstances of what's going on and why that motion was filed to begin with, and then what kind of deals or plea deals that are worked out prior to, unless someone's contesting it. Then it'll go to a full hearing where the probation officer has to come and testify to the allegations.
So we also have summons dockets available. What we do is if at any time the person on your caseload or the individual is having violations that you want to address without necessarily saying, you know, my recommendation is revoke, we're done, there's nothing else that we can kind of try here. If our recommendation is not revoke and it's something that we can go before the judge, we just request a date. So we request a date from the court, whichever court they were placed out of, and we go before the judge. We're there, the individual is there. We kind of present out the violations and we give our recommendations. And there's usually, whenever that happens, all the courts usually have an attorney for the day, they call it, from the defense bar. So there's usually an attorney there to help represent that individual. So if we recommend anything that would amend their conditions, which 9 out of 10 times we are wanting to add a condition to address something, to help with something. So they have representation there to help with that. And also we do throw out that we have a court unit who handles a lot of our stuff. And our officers have kind of the discretion to say, you know what, I really want to go represent this case and be there, or they can send all the paperwork to our court unit, and then the court unit kind of, you know, will handle it for us and represent it, answer any questions that may come up. So that's another thing that we have, is we have those summons dockets to kind of address things that way. And of course, you know, that just takes away the having to go to jail, file a motion, go to jail, wait for that court hearing. It just kind of moves things a little faster and allows us to address whatever's going on and change any condition that needs to be changed or added, and provide the individual with the assistance faster. So that's our courts are a little bit different than Maricopa, it sounds like, you know, but of course we handle our stuff through revocation dockets and summons dockets.
Thank you. Does anybody want to share any other type of variations of probation dockets you might have in your own jurisdictions? Okay, well, have 2 more polling questions. And honestly, number 2 is my favorite polling question. I'm very excited to see how y'all respond to that one, which is really getting down to sort of the time standard question. So the first question is, do you have a specialized probation violation docket? And then or maybe it doesn't even have to have the word specialized there. I would just say a regular probation violation docket. And then most importantly, I'm curious, we're all curious, how quickly on average someone gets from violation or taken in front of a judge from arrest to the violation hearing. Okay, we've got about 26 people who've responded, so a few more. And obviously, if for some reason you don't know, that's not answering one of the questions or both of them is fine too. Okay, I'm going to close the poll and share the results. Okay, so interesting split here. We've got about basically a third of you that do have a probation violation docket and about 2/3 that do not. And then when we're looking about the amount of time, wow, I'm really encouraged to see that 34% of you say that you're able to get that person in front of a judge within 7 days. That's impressive. And I'm hoping and thinking this is beyond folks that are represented on here that are not from Arizona. And then we've got another 25% that are 8 to 21 days. Still not bad, pretty encouraging. And then we sort of get down to the last 2 categories. So we've got 31% of you that are kind of in that, not a great amount of time, but not super terrible yet. The 22 to 45 days, and then a few of you that answered more than 45 days. Does anybody want to talk about those results, or, you know, why you answered the way you did, particularly with question 2? Faculty, any surprises to you all there?
Hi, my name's Jessica Clatterbuck. I am from Douglas County, Kansas, and I am a probation officer with Community Corrections. And we recently, and I would say recently, like within the last 10, like 5 years, right? We've got a probation violation docket. Um, what I was going to say is that it is once the arrest, so on question two, from arrest to when they see the judge, that really has reduced all of that time. So it really, I'm one of the ones that answered the first selection. One thing that I thought would be helpful for us to implement here, that I saw Maricopa County was doing, was the disposition set out because we don't have any kind of, I guess, standardized kind of time frame around how long we can set disposition out from a violation hearing. That really seems to be kind of, I mean, obviously the judge's calendar, but my opinion is that that's directed by the defense as far as like how long they think that it would take for this person to come into compliance and things like that. And so it's not standardized, and therefore, I'm not going to say that everything should be consistent client to client. But when we think about behavior change and, immediate intervention, kind of being associated to that behavior and then the disposition and things like that, I think that that's kind of where I am frustrated sometimes. So I thought that that was an interesting idea.
Thank you, Jessica.
Thank you.
Is there anybody else that would like to share about their probation violation dockets or the amount of time? Or for that matter, if you have any other questions for our faculty, either our folks in Maricopa or Brazoria, or more broadly, some of the other faculty that spoke today. Other than Jessica, is there anyone else that just recently started doing a probation violation docket? Like perhaps started up this year or late in 24?
Hi, Robin, it's Kevin.
Kevin.
I have just a general question. I wonder if jurisdictions have any policy or docket that they handle just for technical violations, and it's not a new arrest, and how they might handle that in their jurisdiction and time frame for that.
Maricopa and Brazoria, do either of you want to take that first?
I can jump in real quick, and Nicole, correct me if I miss anything. So for our probation violation court, the 3 dedicated courtrooms are going to hear majority of those petitions to revoke that just have like any technical violations. When somebody picks up a new charge in Maricopa County, we'll allege that on a petition to revoke. And that person will go to the revocation arraignment for the 2 PV cases or however many PV cases they have. And then that new charge is going to be set in a different division to be heard for those new charges. And we kind of mentioned it in the chat, like eventually those cases can all get merged and be heard together outside of probation violation court. But initially we'll hear the PV matters with the petitions to revoke, and that new charge will kind of run concurrent in a different division.
Thank you, Sean. And Kara and Carla, I think you were about to say something.
Ours would just be kind of similar to the summons docket that we do, because it is those the technical violations, not the new law violations, unless they fall under that certain stipulation. But that's how we would handle them in the technical issues in Brazoria County.
Thank you both. Anybody else want to offer up how you do things in your jurisdiction? Okay, well, guess what we have left to do? We just have a couple remaining things. First of all, before we talk about the resource sheet, which we'll do next, I just want to share with you that we have contact information for all of us. And that will also be part of the resource document we'll send you. So that if you have any lingering questions, please feel free to reach out to any of us. You can even reach out to the wrong person and we'll get you connected to the right person. So please feel free to use this list. And again, this will also be in the resource list. And then I am actually going to turn this back over to Gabby, who's going to talk about this resource list that she's developing. Gabby.
Perfect. Thank you so much. Yeah, so as Robin mentioned, we have a resource list that we will be sharing with everyone that has some of the documents that have been referenced today, for example, the APPA standards, and then the BJS report that Walter and I just spoke about as well. In addition to some other helpful links. We're going to wait about a day or two to send this out because in case anyone has any additional resources they think might be helpful, anything they've written or used that's been, useful for them, we'd love to include that on there. So feel free to send a message to us. We'll send you our contact info first. And yeah, if you have anything you want to share with me, I'm happy to include it. And then we look forward to sharing that with everyone. Thank you.
Thank you, Gabby. And Wynn was so kind to put all of the contact information in the chat too. So if you really want to get in contact with someone like right away, like right after we get done, feel free to grab the information from there as well. And then the last and most important thing I think I get to do today is not only thank all the faculty. We really tried to think through some of the best information to provide you today, and really to thank all of you. Like, I really appreciate the fact that many of you gave your own information about what's going on in your own jurisdictions, and the information in the chat was super useful. And of course, I want to thank the MacArthur Foundation, because we wouldn't all be here if it wasn't for the grants that they've given to the Safety and Justice Challenge, and of course to us and Urban Institute to be able to put this together for you. So thank you so much. A couple of you at the very beginning talked about recording of this. We did record it today, so we will be sure to share that link with you as well in case there's something you want to go back and review. But thank you again, and I hope you guys have a great rest of your Friday and a great weekend, and happy holidays. Thank you.
Thank you.